All right, let's dive into a legal showdown that put the very future of the United Kingdom on trial. You've got the Scottish Parliament on one side, the UK government on the other, and the nation's highest court stuck right in the middle. And the question they had to answer? Well, it could literally redraw the map of Great Britain.
So what was the big question at the heart of it all? It was this, and it's deceptively simple. Can Scotland's Parliament just go ahead and call an independence referendum all by itself, without getting the okay from London? The answer to this one question would test the very limits of power in the UK and, potentially change its future forever. So you might be wondering, how on earth does a court even start to tackle a question that big? Well, it all comes down to a single really important document, the Scotland Act of 1998. Think of it as the official rulebook that lays out what Scotland can and can't do. Let's get into the most important part.
Okay, the entire case, literally everything, hinges on this one concept, reserved matters. Here's an easy way to think about it. The Scotland Act gives the Scottish Parliament loads of power, but some huge foundational issues are kept aside or reserved just for the UK Parliament. It's kind of like if you're renting an apartment. You can paint the walls, you can change the carpet, but you absolutely cannot decide to knock down a wall or mess with the building's foundation. That's a reserved matter for the landlord.
And this table just lays out the battle lines perfectly, doesn't it? On the left, you've got all the stuff Scotland controls, daily life things like healthcare and schools. But look over on the right, in that reserved matters column. That's the stuff only the UK Parliament in London can touch. And sitting right there, at the very top of the list, is the key to this whole thing, the Union of Scotland and England. That is the legal line in the sand.
Okay, so now that we know the rules of the game, let's step inside the courtroom. First up to bat, the case for Scotland. Their argument was really interesting. They said this wasn't about breaking up the UK, at least not in a legal sense. They framed it as a simple act of democracy. Hey, we just want to ask the people what they think.
And this quote, this is the absolute core of their argument. Their lawyers said the referendum would be purely advisory. It wouldn't have any legal power to actually make independence happen. They basically pitched it as a massive, official opinion poll. Just a tool to figure out what the people of Scotland really truly want, with no immediate legal consequences.
So let's break down their legal logic. Point 1, the vote is just consultative, it doesn't automatically do anything. Point 2, because of that, it has no actual legal power to end the union. So point 3, and this is the kicker, the law authorizing the vote doesn't technically relate to the reserved matter of the union. It's a really subtle but clever legal dance. If a vote has no real teeth, how can it be biting into a reserved power?
Okay, so that's one side. Now for the UK government's counterpunch. Their lawyers basically flipped the whole script. They said, hey, let's forget the legal fine front for a second. Let's talk about what this is really for. They wanted the court to look past the technical details and focus on the real-world purpose of the vote. And yeah, this quote just nails their position. They argued that calling this thing an opinion poll was just, not the whole story. Its plain, undeniable purpose, its entire reason for existing, was to be the first step towards independence. In their view, this wasn't just a survey. It was a powerful political act aimed squarely at a reserved matter.
So their whole case really boils down to this. A court can't just operate in a legal bubble. It has to look at the practical effects. In the real world, a yes vote would create this huge, unstoppable political pressure to break up the UK. So they argued a bill that allows for that vote absolutely relates to the Union, which puts it way out of bounds for the Scottish Parliament.
All right, the stage is set. You've got two powerful, completely different interpretations of the law clashing head-to-head. One side is focused on the lack of direct legal power, the other on the undeniable political purpose. After hearing it all, the 5 justices of the Supreme Court were finally ready to deliver their judgment.
After reviewing both arguments, the Supreme Court's decision was
Unanimous, a flat-out no. The Scottish Parliament cannot legislate for an independence referendum on its own. The court's decision was absolute and final. End of story.
So why? Why did they land there? Well, honestly, the court's own words say it best. Lord Reed, the head of the court, made it crystal clear. They sided with the purpose argument. A referendum like this isn't some neutral academic exercise. It's a massive political event with huge consequences, and its entire purpose is to kickstart the process of ending the Union.
You can really see their thinking broken down into these 4 crystal clear steps. Step 1, you have to look at the real-world purpose. Step 2, let's be honest, that purpose is independence. Step 3, that purpose is absolutely 100% related to the Union. And step 4, guess what? The union is a reserve matter. It's like a perfect logical chain, right? It left no wiggle room. The bill was out of bounds.
So there you have it. The Supreme Court has basically slammed, locked, and bolted the legal door on an independent referendum without the UK's permission. That path is blocked. But what's so fascinating is that by closing the legal door, the court has just thrown the issue right back into the political arena. The question is no longer, can they, but what happens now? The legal fight might be over, but you can bet the political one has just been reignited.